Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
The U.S. Supreme Court upholds tuition tax credits in Arizona. Hi, I'm Matt Staver, founder and chairman of Liberty Counsel and dean of Liberty University School of Law. Joining me is Matt Barber, associate dean for the law school and vice president of Liberty Counsel Action. This was a 5-4 decision. Liberty Counsel sent the Supreme Court one of our amicus briefs on this particular issue, addressing the constitutionality of Arizona's tuition tax credit law. In the state of Arizona, Matt, Arizona allows individuals to contribute to part of their taxes and designate them so that they would go toward an organization that would then in turn distribute them to other schools that parents choose, whether they be secular or religious. Well, people filed a lawsuit saying that no money could ever go into the Christian schools. That would be a violation of church and state. The Supreme Court rejected that in a 5-4 decision.
Yeah, good thing they did, man. I mean, boy, how far we've come from the vision of our founding fathers. Now this notion that has been pushed by the ACLU and other groups that somehow government must discriminate against faith-based organizations and individuals even. It just is not in keeping with our history. It's not even in keeping with Supreme Court precedent.
It's not. The Liberty Counsel represented the American Association of Christian Schools, and they include, as part of some of the members of that organization, Arizona private schools that directly would be affected by this decision. And in fact, what happened was the Ninth Circuit Court of Appeals, which is the most reversed court of appeals in the country at the U.S. Supreme Court level, struck down the law, saying that it was a violation of the First Amendment so-called church and state or establishment clause. Here's the situation, though. Individuals can choose to get a tax credit by giving a contribution or a tax. Actually, it's they can make payments. They can give money of their own to this program, and they get a tax credit for it, just like a contribution. They get a tax credit, and then that money goes into an organization from the state that then will just distribute it out to the individual parents. It's not even going directly to the schools. It goes to the parents. So a parent that wants to put their children or a child into a private school, secular or religious, they're the ones who make the choice. The government doesn't choose where the money goes. The parent chooses where the money goes. And this lawsuit was about disabling any kind of choice that might include a religious school. So the fact of the matter is it was upheld 5-4, and now this law can be replicated in the other states around the country.
So once again, the Ninth Circuit Court of Appeals has sided with those who express hostility toward the First Amendment, freedom of religious expression. The Supreme Court has once again overturned the Ninth Circuit, the most reversed court in the land. Matt, let me ask you this. What is it that seems to, this, we talk about this in this impenetrable wall of separation between church and state. First of all, where did that notion even come from? And how has it become so skewed in today's day and age?
Well, it came from the Everson versus Board of Education decision at the U.S. Supreme Court in 1947. Up until that time, the Supreme Court never used that phrase as it relates to the First Amendment. And in that decision, they, for the first time, incorporated to the states the Establishment Clause of the First Amendment. The Establishment Clause, where it says Congress shall make no law respecting the establishment religion, was only applicable to the federal government. Congress shall make no law. Pretty simple stuff. But then in 1947, they went against that interpretation of that clear language and said, well, now it's going to also include the states. So now it's Congress and the states shall make no law respecting the establishment of religion. Then they said, well, what's an establishment of religion? Oh, let's look at a letter from Thomas Jefferson. After he was inaugurated as president in 1801, he sent a letter to the Danbury Baptist, And in that letter, he was explaining why he, as president, would not declare a national day of fasting and prayer. And the reason why he would not is because Congress shall make no law respecting the establishment of religion. Congress could not force the states to engage in fasting and prayer. And so if Congress couldn't do it, as president, he only has the authority to enforce what Congress can do. And if Congress can't do that, can't force the states to participate in religious exercises, then as the president, he can't do that either. It was a states' rights response. He never used that church-state, the wall of separation between church and state phrase before 1801, and he never used it after 1801. And when you look at him when he was on the state level, what did he do? He declared state days of fasting and prayer because that was permissible. States could do that.
So we've gone from this restriction that was placed on Congress, essentially saying they could not establish a federal religion, or Congress could not compel the recognition of religion through prayer, fasting, and so forth. We've gone from that all the way to the point where there are now those who claim, and will take it all the way to the court, I think fueled by the ACLU and People for the American Way and Barry Lynn's group, Americans United for Separation and so forth. This meme has emerged of separation of church and state. You've just explained where that phrase came from, and it has now evolved, and I hate to use that word because we don't believe in evolution, but it has evolved to the point where it means that there can be no mingling of funds whatsoever, and essentially where all religion, all faith, all Christianity has to be separated out and stuck over in a corner, completely separate from any public forum. Our founding fathers didn't think that at all.
No, and that's what some of the strict separationists want to do. They want to disable religions, put it in a corner. They want to actually have government in a hostile, not even a neutral relationship toward religion. So we've gone from this First Amendment Establishment Clause applying to Congress to now applying to the states, which literally, by the way, turns it completely on its head. It's completely contrary to what the founders intended. And then we've not only gone from the federal to the states, but then we've reinterpreted what it means to establish a religion. Look at what happened in the federal government when the First Amendment clearly applied to the federal government. It was President Jefferson who authorized federal money to print Bibles so that they could be distributed to an Indian tribe. President Jefferson did not consider that to be an establishment of religion, and it was President Jefferson who was the most frequent attendee of all the presidents at the then largest church gathering in America, which was where? In Congress. That's where the church met in the nation's capital. That didn't amount to an establishment of religion. So this here would never have amounted to an establishment of religion either. But that's what people have tried to do, to not only apply the law to the First Amendment to the states, but then reinterpret what it means to establish a religion.
So the historical revisionism isn't even subtle. I mean, it is blatant that when you look at the true record. Well, Matt, oftentimes we come up and we have some bad news on faith and freedom, and this is good news though, and this is a victory for freedom of religion, freedom of religious expression, for the First Amendment, and for parents' rights. How does this empower parents?
Well, it really empowers parents because they can make a choice. Parents, in fact, I think educational choice is something that we ought to fight for, and it's something that should be a no-brainer. Parents should have the choice where they educate their children. And
I thought the left was all about freedom of choice.
Not when it comes to education, because they want to use that as a funnel to change people's minds through government education, through failing government education in many respects. Parents ought to be able to have the choice where to educate their children and give them the best opportunity for their future. The interesting thing also about this case, and we're running out of time, but just to leave with this also shows the importance of elections, because President Obama nominated and were confirmed 2 Supreme Court justices. Well, it was Kagan who wrote the dissenting opinion. It was a 5-4 decision. Kagan wrote the dissenting opinion, and she was joined with Sotomayor. And then, of course, you've got a 5-4 decision. So you can obviously see where Kagan and Sotomayor are heading in this church-state controversy. We're one vote away from going the opposite way. Elections do matter. And as we're moving forward in this year towards 2011, we need to be educated and we need to mobilize to make sure that our values are heard in the ballot box, whether it's state local or on the federal level. Go to Liberty Counsel's website at lc.org. We have some resources available. We have the Patriots Handbook. We've got a brand new edition of that and a brand new edition of Take Back America. And those two are published by our new publishing outreach, New Revolution Publishers. So go to the website, lc.org, or call 1-800-671-1776 and ask for the Patriots Handbook, which has the Constitution and the Declaration of Independence, and Take Back America, the new Take Back America. You can call right now for that book. And visit lc.org today for more information.
You have been listening to Matt Staver of Liberty Counsel. Our hope is to encourage and inspire you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email update. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.